Thank you, Mr. Chairman and members of the committee for your indulgence for a long hearing and many testimony of many patriots. I appreciate the proponents and the opponents who testified today. I think it's very clear that they all have deep concern about the delicate and the critical situation of our union. I do want to address a few things that were said by opponents that were not addressed by any of the persons that were called up. One of the things that were mentioned was that Congress can control this convention. That is simply not the fact. Of course, the first reason we know that they can't control the convention is because of the paired powers of Article 5. So Article 5 gave Congress the ability to propose amendments, and they gave the states the ability to propose amendments through convention. The paired power is the founders knew that there would be a time when Congress would be tyrants and the states would need to step forward to propose amendments. So if we think that through any clause or idea that the founders envisioned that Congress could control the Article 5 process of proposing amendments under state conventions of states, then we would assume a certain amount of stupidity on the part of Congress. So they paired those powers so that states could have control over the amendment process just as Congress has control when they propose amendments. There is a U.S. Senator named Sam Ervin who in the 1960s tried 3 times to propose legislation that would enable Congress to propose amendments, or not to propose amendments, but to control the conventions. Those congressional bills were all defeated, and others. So we've seen this before. We've seen Congress try to control it. They've tried to bring bills for it, trying to control it, and that's all gone by the wayside. So we have extreme confidence that Congress will have no control. Another thing that was brought up, that states like New York would have multiple votes over states like Montana, or that the Electoral College would be the way that they would vote. That's simply not true. All conventions of states had one state, one vote. So Montana is an equal sovereign at the convention of states, and we will have just as much weight with our vote as with the state of California. I bristle every time opponents use the word con or constitutional convention. That is fallacious. It is not right because Article 5 does not give the power for a constitutional convention. It simply gives power for an Article 5 conventions of states. Even Article 5 itself limits what we can propose in amendments. It says you can't touch state sovereignty. It talks about Article 1, Section 9, I think, of Article 2, Section 9, I think, of the U.S. Constitution, like slavery. They couldn't mess with that, and they couldn't mess with other state issues. So even Article 5 limits what conventions can bring about. Another thing that was brought up that I think is seriously flawed is that none of the founders said that the Philadelphia Convention had authority to do what they did. That is completely false. All you need to do today is go read Federalist 40. Madison spends all of Federalist 40 saying that they did have the authority to propose the convention as it was done in 1787 in Philadelphia. So that's fallacious. John Marshall at the Virginia Ratification Convention said, many gentlemen have already said that we had the authority to do what we did in Philadelphia. So many founders did say that the people at the Philadelphia Convention had full authority to do what they said. All that Mr. Brown and his associates are doing is quoting anti-federalists. It's like us coming here today and someone saying the only thing brought up is what the proponent said and not what the opponent said. The anti-federalists had many things that they said, and the federalists had many things they said. What Mr. Brown says is only what the anti-federalists were saying, not what the federalists were saying. He was just bringing one side of the argument. Then this other argument that the conventions can do anything they want is ludicrous. Even the Montana Constitutional Convention was limited. When the Montana Constitutional Convention tried to appropriate money for education, the court struck them down and slapped them down and said, you can't do that, that's not in your enabling act. So conventions are simply bound by their enabling acts, by their commissions, and by their limited application. Another thing that was brought up was this letter by Madison to Tuberville in 1787. Madison actually wrote that letter before the Constitution was even ratified. That is totally taken out of context. Madison wrote the letter was basically saying, we ought to ratify this first and give it some trial before we start having another convention. So that letter is taken out of context. Madison wrote it before the Constitutional Convention was even ratified. So, Mr. Chairman, I would just encourage us to not listen to the fearmongers. All the opponents have to do is say they're just naysayers. We are offering a constitutional, well-thought-out, extremely well-researched option for us to rein in the abuse of the federal government. I put on all of your packets today the Jefferson Statement. I would encourage you to read that. This is a statement from the top constitutional scholars in the United States of America. They have all agreed that the Convention of States is a legitimate constitutional process for us to pursue to remedy our problems. I also want to finally bring up, before I close with a couple of quotes from the founders, is what Robert Brown, and this was one of Senator Manzell's questions, about one of the articles or one of the potential amendments that was brought up at the 2016 Convention of States Simulated Convention. I'm going to read it to you, and I'm going to ask each one in this committee if they wouldn't support this. It says, the legislatures of the states shall have authority to abrogate any provision of federal law issued by the Congress, President, or administrative agencies of the United States, whether in the form of statute, decree, order, regulation, rule, opinion, decision, or other form. Such abrogation shall be effective when the legislatures of 3/5 of the state approve a resolution declaring the same provision or provisions of the federal law to be abrogated. I would submit that every one of us in this room would support that amendment. That is to say that, for example, when the ACA was passed, maybe not Senator Bennett, or I don't know, but when the ACA was passed, if 3/5 of the states could have had the ability to abrogate that law, it would be done. That would never have happened to us. This was a well-thought-out, drafted amendment. And by the way, this is just a suggestion. You still have to ratify with 38 states. Finally, Mr. Chairman, I just want to reiterate just a little bit that the United States of America is deficit spending or printing 47 cents of every dollar they spend. There are some simple, universal truths. Number one, universal truth. You cannot outspend your income indefinitely without dire consequences. The borrower will be servant to the lender. John Cogan, in a book he recently wrote called The High Cost of Good Intentions, suggested that whether we had a president that was a Republican, a Democrat, a Congress that was controlled by Democrat or Republicans, whether we had a lot of money or a little money, that every one of those situations we have advanced the entitlement state. I blame Republicans as much as Democrats. And as a matter of fact, Republicans are historically worse than Democrats in deficit spending. So if you think that we are going to elect Republicans to control deficit spending, you're living on the wrong planet, because it's not going to happen on this planet. There's a second universal truth. Absolute power corrupts absolutely. And Washington is hopelessly corrupt. And we need to rein in the power and the jurisdiction of the federal government. And this Article 5 solution is a well thought out, constitutional, well researched. I don't know of a better researched proposition by constitutional scholars in America than this one. Finally, James Madison said this. This was a letter in 1830. Amendments, therefore, will be necessary. It would be improper to require the consent of the national government or legislature because they may abuse their power and refuse their consent on that very account. Then he said in Federalist 43, Article 5, moreover, equally enables the general and the state governments to originate the amendment of errors as they may be pointed out by the experience on one side or the other. So Madison pointed out that the federal government can propose amendments and the states can. It was a legitimate function of the state. Finally, I want to bring your attention to what our President Ronald Reagan said in his 1984 State of the Union address. He said this: "We cannot depend on Congress to discipline itself. We must rely on the states to force Congress to act on our amendment." He was talking about a balanced budget amendment. Fortunately, our nation's founders gave us the means to amend the Constitution through the action of state legislatures. This is the only strategy that will work. Ronald Reagan, 1984, State of the Union Address. Members of the committee, I beg your due pass. Thank you.
I'm here live in Philadelphia at the Tomb of the Unknown Soldier. When you hear the phrase lives, fortunes, and sacred honor, these are the folks we should think of, those who anonymously gave their lives. Well, today you have a chance to volunteer. You need to volunteer for conventionofstates.com, the movement that's going to save the country. These folks are willing to step up and give everything. We need you to give just a little bit. Go to conventionofstates.com and volunteer today.